Good evening, everybody. Welcome to another edition of my weekly presentation, Legal Ease, where I try to answer your questions and try to inform you about things that are important, that are relevant to the job as a personal injury attorney. Tell a little bit about how I help my clients and how I try to be of service to them. And as part of that process, we often go into litigation. And litigation is the part of the case where we've attempted to settle the matter with the insurance company. We are not able to for whatever reason. Either the insurance company is being unreasonable or the client's expectations may be a little bit high, despite our efforts to try to manage them. But we find ourselves in a situation where we are always trial track. However, there is one very important mandatory stop along the way, and one very, very effective and helpful tool, and that is mediation. And I'm happy to have as my guest today my favorite mediator and my brother, Tom DeBari. He's a certified circuit court mediator here in Florida. So let's just get started. Tom, tell us about yourself.
Well, good evening, Chris. Thanks for having me on. I've been in practice in the state of Florida in law practice for 29 years, a graduate of that wonderful Academy of Legal Education, Stetson College of Law.
Well.
Yes, you do. Yes, you do. And I think some of our viewers do as well. I've been a mediator for approximately 14 years now, concurrent with the law practice I still maintain. But as mediator, since that's my primary focus, my law practice does not involve representing the interests on one side or another for whom I mediate, such as insurance companies, plaintiffs' law firms, and the like. So I'm still a lawyer. I'm always in the game, always keeping up very much on the latest changes in the law and in the world of personal injury in particular. The changes, the law is pretty volatile. It's, it changes quite a bit. So I mediate with most of my time professionally. I'm also an arbitrator. I've got 2 arbitrations actually coming up next week. That's another area. I don't know, Chris, if you've gotten into that on your last show, but that's another area of dispute resolution as well.
Tell us, what is mediation exactly?
Mediation, it's just basically it's a settlement conference. Typically, as you alluded to, it's court ordered. But sometimes not. Sometimes the parties in a dispute will just come together, and sometimes even before litigation, to sit down with the other side, with the mediator like myself presiding, and to engage in an exchange and discussions about the case, the way each side sees the case, the way the case might be resolved by a jury one day. And typically the attorneys and the other professionals using their experience as kind of their litmus test, they'll give it their best guesstimate. And in every mediation, I think, that I've ever presided over or attended as an attorney, the phrase crystal ball always comes up by one party or another. And while no one has that crystal ball, at least we can look back in cases of the type we're mediating as different parties and say, well, historically, cases have been resolved. Cases like this have been resolved in this particular range through settlements, or in another particular range, perhaps by juries in that venue. So it gives the parties a chance to sit down and talk with each other. It's the first, sometimes the only opportunity that we get to have all the decision makers in one room, albeit a virtual room nowadays, but puts everyone together. It gets everyone focused on that case at that moment in time. And that dynamic, with open-mindedness, of course, and a willingness to compromise, can lead to your best day to get your case resolved and to get it settled on your terms.
So let me just clarify about something that some people have confusion about. So your job is not there to give orders or make people do anything?
No, as much as I would like it to be, I really can't do that as a mediator. As a mediator, my job is to really shepherd the process. Get the parties together, make everyone as comfortable as possible, and get them to talk about the case, and use my experience as an attorney over the years and as a mediator to try to bring the parties together to fashion their own resolution, to make their own decision about the case, to collaborate and to resolve it between the parties that are interested, rather than turning it over to a jury one day of 6, presumably disinterested people.
Now, your history, you not only represented plaintiffs in litigation, but also defendants in litigation.
Correct. For a good many years, about 8 or 9 years, did almost exclusively defense work, represented insurance carriers, state subdivisions and entities as well. So I've got some experience on both sides, been to trial on both sides, and it gives me perspective. It doesn't mean I know everything, but at least I've been on both sides. I think I'm sensitive as a mediator to what happens in the room when I'm not there, and I think that's a benefit. So
it sounds like it gives you a well-rounded perspective, if nothing else.
Yeah, I feel that it does, and I feel it's been commented to me by folks who've hired me, clients, that they appreciate the fact that I've been on both sides, and I can, I've got a perspective, from the middle, quite honestly. So
now, tell us a little bit about what kind of process you had to go through to become a mediator.
Typically, you attend a course. I believe it was 40 hours when I did it back in 2003, 2004. You go through that, and that's, it's 40 hours that when you're in the middle of it, it seems like it's kind of rough, but it's, and they don't let you slack on a minute. It's not like college. You get there late and get credit for the class. No, it's a pretty intensive 40-hour course. Thereafter, you have a small, short practical period where you will shadow other certified mediators, and see what the process is all about from the inside. And at some point, you'll get to co-mediate with the actual mediator until you get your certification. So it used to be 3 observations, 3 co-mediations, and then you pretty much got your wings, and then you were beating the bushes and bringing the cookies to people and saying, please use me as a mediator. So.
I received my mediation certificate about 8 or 9 years ago myself. That I don't mediate because I practice in the area of plaintiff's personal injury. So I can't really be a mediator and be a personal injury attorney at the same time. But I do remember that process, and you're absolutely right. It is absolutely not a moment wasted. I had a very good teacher, George Castagna, who's very well known in the mediation circles, and he really did a good job. We have some people checking in here. Juan Zamora with the Roma's Nations here. Hey, Juan, thank you for checking in. Lisa DeBari is here. Our mother is paying us a visit today. And Vanessa Gonzalez. So say hi to Mom.
Mom always did like you best.
So as far as circuit court mediation is concerned, what is your particular area of expertise, if you have one?
Can't say expertise without the certification, but I've concentrated my practice over the years as a lawyer, both on either side in the area of personal injury. So most of the cases that I attract as a mediator, I'm hired, I think, because of my experience in personal injury, workers' compensation, medical malpractice, and all kind of offshoots of negligence claims.
Wow, sounds like you've done a lot.
Seems like it. I got some gray hair, so that's. I guess that means something. I don't know. You looks like you're more experienced than me from that angle. I don't know.
So you're a litigant, and you learn that you need to go to mediation. So you and your attorney do whatever preparation you're going to do. You step into the mediator's office, and what is that process going to be like for a litigant?
Well, what I'd like to do, and I've learned this, I think, from being an attorney at mediation and bringing clients to a mediation as their counsel, very often for the first time. Very often that's their first experience, aside from a deposition, perhaps, with the process. And I think the biggest thing, most important thing in my mind is, number one, to make them comfortable. They're typically the only ones in the room that have never done this or have done it very infrequently compared to the rest. The first mediation I ever attended, it was interesting. The mediator, who's actually a great mediator, well-known mediator, he gave a very good talk, very nice introduction, but it was done in the room with everyone. It was done in the joint conference, and it appeared as if you were just talking to my client and almost came off as a lecture sort of thing. I didn't think much of it at the time, but after the mediation, the client told me, it just felt like he was singling me out. I go, yeah, I guess he was. And the client felt a little awkward about that. And I felt horrible, but I was a little skinny lawyer with a mullet. I really didn't know, what was going on.
I remember that mullet. I had one too.
Yeah, it was Stetson. It was standard issue. It's Stetson. But my thing is now I always make sure that I at least greet the plaintiff and the plaintiff's counsel up front, talk to the plaintiff a little bit, just, how's it going? How are you? How's everything, in life moving? Just try to get a little bit of rapport, make them feel at ease. And then at that very moment or intertwined with that, I try to introduce them into the fact that in a few moments, you're going to hear someone say things about your case that you might find unflattering, or that you might disagree with, or that might flat out just make you angry to hear those things. So I try to prepare them for those things as well. And I'll tell you, I've had the privilege over the years, and just today, as a matter of fact, just mediating with absolutely fabulous attorneys on both sides. And my defense people today, they set up the mediation, I think, as well as it can be set up. They talk to the plaintiff just very, very politely, very professionally, very friendly, and it made my job, kind of makes it easier and it makes it harder, because when they set the table like that for me and they create that atmosphere that's conducive for mediation, pressure's on this guy to get it done. So they really do, but they make it easier because they put the plaintiff in a frame of mind that sort of dovetails with what I was trying to do initially, and that is make them feel comfortable, make them feel like they're a participant instead of just a spectator, because you have all people throwing legalese around at them perhaps. So I think the biggest thing in mediation, what I try to accomplish, and I appreciate my attorneys that work with me with this, is making everyone feel comfortable.
Comfortable is an important thing. Now, when you give your opening speech to the plaintiff, or to the plaintiff, basically, if you're talking to the plaintiff, what is the thing you hope they take away from that?
I hope they take away a sense of empowerment. I hope they feel, after my opening comments, that they're a decision maker today, because they are. The reality is they are, but some folks, they don't perceive it that way. Everybody around them is wearing a suit and a tie and, looks great. And these folks may not be from that world where that happens. And I'm just very sensitive to it. I want them to know that they're the boss today, and that nothing can happen in mediation without that client's knowledge, consent, and blessing. And then I contrast that with a trial environment where everything and anything can happen in a trial, and we don't need your consent, your blessing, or anything else from you.
So a plaintiff is not a decision maker in a trial?
Not as far as I've ever seen. Usually the decision maker is wearing a black robe, and he's got 6 or 7 helpers sitting off to the side. So, okay. Yeah. So going back to your question, a sense of empowerment is what I want that person, that litigant who's new to the process, to walk away with from that opening.
Now, the mediation itself is a strictly confidential process, is it not?
It is. If you are not a participant, if you've not been invited to the conference as an attorney, a party, an adjuster, mediator, what have you, you are not entitled to be there. As a mediator, I could kick anybody out who tries to enter. That's just how it works, and the judge will uphold me.
What about the things that the parties talk about, or may go back and forth between the party and the mediator? Are you allowed to talk about those things outside the mediation?
Outside the mediation?
Yeah.
No, typically whatever takes place within the mediation, any statements that are made are not allowed to be repeated outside the context of the mediation.
Can you tell a judge?
I've never had a judge ask what's happened at mediation, but I've had a judge rule upon my motion for protective order that I'm not allowed to talk about what happened in the mediation.
Oh, so litigants can be pretty confident that what happens in Vegas stays in Vegas.
I would say it's a good bet. I use the word virtual certainty when I tell people that at the beginning. I can tell you with virtual certainty that nothing that we talk about here today is going to be repeated before a judge or jury. There's, exceptions here and there, criminal acts and things of that nature, but those things have never presented in the mediations in which I've presided.
Now, how do you approach new cases?
As a mediator?
Yeah.
Can you be more specific? What do you mean by that? Like, how do I approach?
Well, I mean, do you have a different way of approaching cases based upon who the attorneys are, what the issues are in a case? If it's a medical malpractice case, as opposed to, say, a regular garden variety motor vehicle accident?
I would say certainly. From a point of, I guess, part of mediation, it's a bit of salesmanship. So there's part of that goes into it as well. You want to be able to speak the language of the person you're talking to. You want to present the correct demeanor to people that you're dealing with. Sometimes it's a lot different than others. So you don't want to, you don't want to offend people. You want to be culturally sensitive. You want to be environmentally sensitive. You want to be professionally sensitive to the people with whom you're dealing. And sometimes that varies from room to room. Very often it does. So you want to have a good sensitivity for the folks you're dealing with. And since I've been at this for so long, I have a pretty good idea when people come to see me, what they like, what they don't like, and what I think will be most effective, socially, to make everybody, again, feel comfortable, feel at ease, to have the person who's new to the process trust me. Here I am, this guy they don't know, they've never heard about. They maybe got a notice with my name at the bottom, 3 months before. And in a very limited time as the mediator, I have to greet these people, talk to them, get a rapport, obtain their trust, and be able to, at the end of the conference, sit down and get their case settled for them if that's what they want to do. And there's a great element of trust that I do not take for granted. That has to be cultivated in a short time. So I try to, going back to your question, I try to be as sensitive to the particulars and the sensitivities of the parties, the attorneys, the adjusters, as I possibly can.
So I guess it's very important to put people at ease, particularly if they're going to be in a situation where they may be compromising. The saying is that a good mediation is one where the insurance company pays more than it wants to and the plaintiff takes less than he or she wants to. Do you think that's a pretty accurate statement?
I've heard it described by many on both sides in that very way. People say, if everyone walks away hurting a little bit from the table, it's been a good settlement. And I've never settled. And I tell folks, quite honestly, especially at the beginning, if this case settles, there's going to be a lot of happiness in this room, and it's all going to reside right here in me, because I will feel that as the mediator, I had something to do with that, maybe, but you and you and you and you're not going to feel very happy. You're going to feel kind of anticlimactic, like, oh, all right, this is it. This is a settlement. Okay, shake hands, walk away. DeBari, you're a nice guy. We'll see you later, whatever. But no one's doing cartwheels, and that's the essence of a settlement, because you're settling. You're doing exactly that. You're not getting what you want, and you're probably paying more than you think you'd have to pay if the case went to trial and you defended it the way you feel you can defend it.
So this is a cooperative, non-adversarial type of setup.
We hope it's not too adversarial, but I emphasize that as well. It is a cooperative, collaborative environment where the parties work together to fashion their own resolution, their mediation settlement agreement that concludes their case.
And do you, as a mediator, follow any particular style of mediation?
Style as far as an individual style, like a mentor type of thing? Yeah, I would say that I probably emulate some of the people who have gone before me and some of the people who have shepherded me through that process. So I definitely think I've maybe adopted some of their approaches, their mannerisms. And I'll be quite honest with you, in all the mediations I've done, I learned something in every mediation. I walk away from that conference with a new way to look at something, with a new way to look at an argument, with a new way to make an argument, with a new appreciation for something that I might have overlooked for years as an attorney. Sometimes I get a great line out of somebody in mediation that I can repurpose and use later. And the first 3 times I give him credit. After that, it's all mine. But I have to say that over the years, I've gotten some great material, from people, because they said things at that moment that were so pertinent and so relevant, and said it so much better than I could say it, that I will say, may I borrow that? May I use that in my next mediation? So very often that happens, because like I said, I work with, just privileged to work with great professionals. And I couldn't be any happier with that.
Well, if I could mediate with you, I would.
You could. You're honest guys. We actually could, but it might raise some eyebrows. So.
Of course it would. Well, listen, thank you very much for being a guest on my show tonight. Was there anything else that you wanted to add?
Give me the hook already? All right.
I got to get home and eat dinner.
I understand. No, Chris, thanks for having me on. It's been a pleasure speaking with you, and hopefully speaking with some folks in the audience. And if anyone has any particular questions, they can certainly direct them to me. I'm on all kinds of social media. I'll answer certainly what I can answer. And if they have any questions for you, they know where to find you. So.
All right. So, thank you very much for being a guest. And actually, folks, thank you very much for tuning in tonight. This was my first show with a guest, so who better to have than my own brother to be my guest. And I appreciate you all tuning in. And if you liked what you saw today, please feel free to share, comment, or like below. And please come join us next week, where we're going to be discussing DUI law with Mike Isaac, attorney from Tampa. So look forward to seeing you then. And thank you for my guest for showing up. And thanks for tuning in, folks. Have a great night.
Yes, like Carson.
What was it?
I'm hoping to return as a guest host, like Seinfeld used to do on Carson. All those guys. So I'm hoping to get invited back.
You did a great job tonight, so I think you got a pretty good chance.
Sounds good. Thanks again.
Have a good. Bye-bye.